Welcome to Law and Crime Report. My name is Bob Bianchi. The Joel Guy Jr. case, which you know we cover gavel to gavel, all these trials here at the Law and Crime Network. I can tell you, having been a homicide prosecutor, as an assistant prosecutor, and a homicide prosecutor as the head county prosecutor, there are cases that just stick out that are just beyond belief, and this is one of them, having been to many crime scenes. He was convicted of murder and dismembering of his parents on Thanksgiving Day in 2016. On October 2nd, 2020, he was found guilty by a jury of both murders and the abuse, 2 counts of a corpse. The prosecutors alleged during the course of that trial that he had been planning that murder for a period of time when the parents said that they were going to be retiring and cutting him off financially. There was a notebook that also mapped out some of these plans, but I think probably the most horrific part of this was the dismemberment of the body parts, including his mother's head in a pot that was boiling on a stove. So, you know, these are the kind of cases that when you walk into those crime scenes, you just know you're never going to be the same, but you go ahead and do your job. Prosecutors and police did that. Now, he was already sentenced on the 2 counts of murder, and today he was sentenced on the abuse of a corpse. So let me go right now to a SOT, if you will, a clip, if you will, of the verdict in this case. And you could take a look at the face of just evil actions. I don't like to call people evil, but I mean, this is about as close as you can get. Let's take a listen.
We, the jury, find the defendant, Joel Michael Guy, guilty of first-degree premeditated murder of Joel Guy Sr.
Count number 2, please.
We, the jury, find the defendant, Joel Michael Guy, guilty of first-degree premeditated murder of Lisa Guy.
Count number 3.
We, the jury, find the defendant, Joel Michael Guy, guilty of first-degree felony murder of Lisa Guy.
Count number 4.
We, the jury, find the defendant, Joel Michael Guy, guilty of first-degree felony murder of Joel Guy Sr.
Count number 5.
We, the jury, find the defendant, Joel Michael Guy, guilty of felony murder of Lisa Guy.
Count number 6.
We, the jury, find the defendant, Joel Michael Guy, guilty of abuse of a corpse of Joel Guy Sr.
And count number 7.
We, the jury, find the defendant, Joel Michael Guy, guilty of abuse of a corpse of Lisa Guy.
Thank you, Madam.
Well, there was the verdict, and you saw absolutely no emotion on the defendant's face. And obviously, after a verdict like that, there'll be a sentence. Let's take a watch.
And in this case, Mr. Halstead is arguing this factor doesn't apply. In that the defendant has no prior criminal history. He is going to be in his 70s, if I ran his concurrent with another before he got out of jail, and would unlikely be a threat to society. And I'm sure there'll be a lot of physical deterioration in Mr. Guy over the next 51 years. But even then, it's his mind that I'm most worried about. He certainly has evinced a sick and depraved mind. He's certainly not mentally ill. He knew exactly what he was doing. He didn't go about it in a very intelligent way, but in any event, I do think confinement for an extended period of time is necessary to protect society, because I don't think Mr. Guy's mind is going to change at any point. And finally, the aggregate length of the sentence reasonably relates to the offenses for which the defendant stands convicted. And I am aware that if I give him the maximum sentence and stack it, that there'll be 130 years before he'd be eligible for release. Quite frankly, if it was 300 years, I don't think that would still be sufficient to reasonably relate to the offenses for which he is committed. And so I was thinking, is there any closing remarks I need to make in this thing? And there's not a whole lot for the court to say. The case really speaks for itself. Mr. Guy, I think, thinks he's a lot smarter than he really is. And some of the things he said in this letter that the state has presented, where he's threatening to blind his cellmate so he can get a cell to himself, which, not thinking that through any better than he thought through these homicides. And so this is just a pure act of evil, and it was done in a really unintelligent way. And I think that's probably what would bother Mr. Guy the most, is me saying he's unintelligent. So, Mr. Guy, at this time, I'm asking you to stand up. I'm going to sentence you in this remaining counts. Joel Michael Guy and Dr. number 110145. The court has already pronounced a life sentence in count number 1. The court is going to merge count number 4 into that life sentence. Count number 2, the court has already entered a life sentence for Lisa Guy, and count 3 and 5 version of that. I want to order that count 2 run consecutive to count number 1. In count number 6, abuse of corpus of Joel Guy, I sentence you to the maximum sentence of 2 years run consecutive to count number 2, and a count at a 30% sentence rate. Count number 7, abuse of corpus of Lisa Guy, will be the maximum sentence of 2 years and 30% consecutive to count number 6. So it's a total sentence of 2 life sentences consecutive with 4 years stacked on top of that.
There you go, completely stoic as he was getting the maximum sentences. They were all consecutive. Judges are going to show no mercy there. Let me bring in 2 great guys. Gabriel Sepulveda Sanchez out of Los Angeles, personal injury attorney specializing in car accidents as well as catastrophic injury cases, millions of dollars in verdicts and judgments. And Brian Dunn, a managing partner at the Corcoran Law Firm, trial attorney, managing partner, as I indicated, police misconduct expert, especially with regard to over 200 state and federal civil rights cases involving mainly police shootings and multiple 7-figure verdicts. Guys, I mean, look, as a prosecutor, as a homicide prosecutor, it's a guy like this that you just can't, you just unimaginable. It's not just up close and personal. There's not only a financial motive, which is such a minor motive to kill your parents, but, you know, dismembering him in the way that he did, putting them in chemicals, his mother's head in a pot. Brian, this is about as bad as it gets as far as
Absolutely.
criminal-related activity. What do you think?
Bob, you said something earlier that really moved me, because you basically said that you've been to crime scenes, you've been involved in these prosecutions, you've done it for decades, but there's certain cases that you remember. And there's certain things that just stick with you. And this is I'm so happy you said that, because I was thinking the same thing. The psyche of a lawyer that is involved in these types of very intense fact patterns is a unique thing, and you carry it with you. And this case is so egregious that you start using words like evil. And evil is usually a word that we kind of try to stay away from because it's capable of so many interpretations. But this is evil. And that's really the only word that fits. And when you see the judge reading the sentence, he's going through exactly what you went through, Bob. He's never going to forget this. Neither is the court clerk, neither is the court reporter, neither is the bailiff. And when you start talking about what is the defendant's reaction going to be, there is no proper way to take a verdict like this. He probably knew that he was guilty. He knew that it was going to be a string of guilties all the way down. He's showing no emotion, but I don't think he showed any emotion when he was doing the act. And what we really go through when we see something like this is we start feeling a level of revulsion that's so deep that we want to distance ourselves from it. We want to act as if there's no way a human being can do this. But every once in a while, we do get confronted with this reality. And I really felt what you were saying in that regard, Bob, because I've been there myself.
Yeah, I appreciate that, Brian. And, you know, as defense lawyers, they're entitled to a defense. We all get that. There's a greater principle there. But sitting there and defending things like this, and typically these guys aren't the easiest clients on top of it to represent. And you got to go forward with it anyway, but it leaves a mark on everybody. That excellently put, Brian. The prosecution wasn't about to go down without a fight. Certainly they won the case. They were going to be making their arguments as well. Let's take a listen.
She paid for all of this, okay? Because she was supporting him. And think about that. She paid for the drain cleaner she was dissolved in. She paid for the muriatic acid. She paid for the work lights that he thought he was going to need. She paid for the sledgehammer. She paid for the timers. She paid for the plastic sheeting. She paid for that garden hose. She paid for the small sprayer in the master bathroom. She paid for the big sprayer, the bleach sprayer that was left in the floor of the kitchen. She paid for those garbage bags. She paid for his socks. She paid for his red potato salad that he got when he was buying his medical supplies, because he worked up an appetite after all of that, and he was in the mood for some red potato salad. Think about that. Think about that. She paid for the tubs that she and her husband disintegrated in. She worked all those years at Jacob Engineering to put him up, to keep him in his lifelong whatever program he's in at LSU. And you know what, ladies and gentlemen? She was still looking for a job in Seguinsville. Do you remember Renee Charles telling you that? She wasn't going to cut him off. She was going to find a job up there. She was going to keep supporting him. Oh my goodness. She gave him everything he wanted. And then she had the nerve to tell him that they retired and needed a break.
Well, Gabriel, to Brian's point, what we were just talking about in the previous discussion, what a powerful presentation by the prosecutor in every way, shape, or form, including she bought the acid she was dissolved in, and then on and on and on about how she provided for all those mechanisms of their own death and their injury. Very powerful. Again, to Brian's point that we were talking about, you can see the trauma on the prosecutor's face when she's like, "Oh my gosh." I mean, what are your thoughts about all of that as a trial lawyer?
She's doing a great job at just painting the story and basically humanizing the victims and really getting into detail of what a mother's done. She prepared the potatoes that he was going to eat and the little things like that trigger these emotions. As a jury hears this, they're thinking about what their family would be doing. She talked about buying him whatever it was and being killed in the own house that she's worked hard for and being dissolved in the bathtub and that she cleans. And this, you have to, as a trial lawyer, you need to give those details, those little stories and pictures to a jury so you can humanize that victim. That's not one of the things that I see the best trial lawyers do is they humanize everything. It's not about what's on paper. It's about bringing those words on paper to life. And she's doing a great job of that right now.
Brian, to Gabriel's point, and I think it's a good one, that I'm a kind of lawyer that likes to work from the gut and the common sense place, not so much with the forensic and the DNA, because I think it gets overly complicated. OJ is an example of that, particular situation. It would have been much more powerful to talk about the car ride without counting $10,000 in cash, a mask, and a gun. It's not the reaction of someone who knows his children are orphaned. She's kind of doing the same thing here. And I'm curious about your thoughts about how effective that is in front of a jury. And then secondly, being a high profile trial lawyer like yourself, what do you do when you got to sit next to somebody like this, where they have absolutely, apparently no remorse? I've had it happen very few times. Most people are remorseful. Most people do feel bad. It doesn't seem like that at all. How do you deal with that as far as representation?
Well, you just have to go through it and hope you don't develop, excuse my language, hope you don't develop a drinking problem in the process.
Yeah.
The prosecutor is feeling this, okay? She's feeling this deep in her soul. And one of the things you have to understand is this is her rebuttal argument. She's already given a very long, well thought out, probably very intellectual opening argument. The defense gave their argument, and now this is her last chance to talk to the jury. And it's really interesting. I'm glad you brought this up, Bob, because she's talking through a mask. But it's as if the mask isn't there, because what she's doing is she is, in a way, exercising some of the demons that she's feeling by talking about this. And Gabriel's point was awesome too, because you got to humanize these folks. But I think you got to understand that the lawyer is human too. The prosecutor is human too. And it's not lost on her that there's no remorse here. It's not lost on her that this defendant doesn't seem to care at all about what happened. But what she's got to do is she's got to figure out a way to put the pieces in her psyche together, to get up out of bed and go back to work again after having dealt with something that's horrible. And it's for those who may be listening, who are not lawyers, it's a lot harder than it looks.
Brian, I love your point about alcohol, and because alcohol and drug addiction is a major issue with attorneys, a lot because of this. And when I was a county prosecutor, I watched very carefully because I went through it myself, where after a while you are burned out after trying homicide case after homicide case, and including the rape unit. That's the sexual abuse unit, especially with children.
As it gets.
Another one people can burn out very quickly. So their bosses need to be very attentive to that. Guys, great commentary. Appreciate it. We got to take a quick break. We got more on the Law&Crime Network, as you know, always. So stick with us. We'll be back. We're breaking down the Erica Stefanko case, and just so it's clear, because it can get a little twisty, Erica Stefanko and Chad Cobb had a daughter, okay? GC, that's how we're referring to her. GC is the daughter of the defendant in this case, as well as Chad Cobb. Chad Cobb is now pled guilty and is spending life without parole and has testified in the case against his ex, Erica Stefanko. She is now testifying, GC, for the prosecution in this case with respect to a very important element of luring the victim, Ms. Biggs, to an abandoned location, saying that Stefanko and she overheard a conversation with her. So this is a very interesting witness. She's 15 years old now. I believe she was about 10 years old or maybe less when this incident happened. And I should note, Ohio allows a person who is over the age of 10 years old to testify, even if they're testifying about something that had occurred prior to their 10th birthday. I'll find out that exact date. She may have been 7 at the time that this supposedly happened. Let's take a listen.
Do you remember your mother's death?
I remember it happening, yes.
Okay. Do you remember before that happened that there was a custody battle over you?
I don't remember the custody battle.
So you don't have any recollection of your mom and dad fighting over you?
No.
So now that night, you said you remember when she died. Do you remember being asked about that?
Yes.
Do you have any recollections of that night?
Yes, Erica made the...
Oh, hold on, let me just ask you a question first, okay? At the time, did you know that this recollection that you're about to tell us about was associated with your mother's death?
No.
It was just a memory you had, independent.
Yes.
So tell us what it is now that you recall about that night.
I
Well,
can...
hold on for a minute. Attorney Laprenzi, I would prefer that you ask the witness specific questions instead of it be a narrative context. Thank you.
Do you have a memory of Erica making a phone call?
Yes.
Tell us about the phone call.
I can remember her, and I remember hearing it but not seeing it. And I know she ordered a pizza. I don't remember what she said that was on it. And I can remember that she did not use her name.
Do you remember what name she did use?
No.
Do you know where you were when you heard this phone call being made?
In the back of a car?
Do you remember what kind of car it was?
No.
Who was with you at that time?
I know Erica was in the passenger seat, and at one point of time she was holding my half-brother Casey, and then I remember seeing AL in the back of the car with me.
All right.
Okay, I got to make a big correction here. So she is the GC is the daughter of the victim, Ashley Biggs, and the defendant, Mr. Cobb. The Stefanko, who is now on trial right now, is the person that she is testifying, GC, was making that pizza order. So I just wanted to make sure that that was clarified. Guys, I think that this is compelling testimony, but while the pizza theme is consistent, and while the pizza theme about luring them into a building is consistent, there were inconsistencies between what she testified about the ordering of the pizza versus what Chad Cobb had testified to. As I understand it, she was indicating, as you just heard right there, that it was in a car where that was being done, the ordering of the pizza, where Chad was saying that he overheard the call being made at their home. Anyway, what do you think about her testimony, Brian, in terms of its efficacy? And again, we're talking about somebody who was a child testifying now years later. Does the jury take that into consideration, or do any of those contradictions make a difference?
Well, you know, the players in this case are a little complicated to keep track of. But if the prosecution is bringing GC, and if this is a prosecution witness I would have to say that it might not be the best idea to even put her through this. You have to think about the trial not just in terms of winning, not just in terms of the public safety, but how is this trial going to impact the family? And the greatest victim of all is GC, because she's lost not only her mother in the most brutal way, but she's also lost her father. And it's no secret that the circumstances of this incident have a pizza delivery call being made that leads to this horrific crime. What is added by putting this little girl through this? What do they gain strategically? The concept of a child testifying is a very dicey thing to begin with. But when you have a situation where this child has been subjected to such incredible trauma, and then you're trying to clarify facts with him, I noticed that the attorney was doing a lot of leading questions to try to get where he wanted. You're putting a strain on this mind that is only 10 years old. That is something that you should really take into consideration. And what did she add? I don't think she added enough she was a child when it happened. I don't think she added enough to really justify this.
Okay, fair point, Gabriel. I've called young witnesses to talk about the murder of their parents, and the real sad part of this is that the kid is always the one orphaned at the end of this. Somebody goes to jail, somebody's dead, but nevertheless, it could be the prosecutor did it because they believe that the jury will believe her. The jury, he can't, the defense cross-examine on, you're a murderer, you did this horrible, brutal thing, you have a conviction. But she did say she loves her dad and she wants to see him get out. I mean, she says he's my dad, of course. So she does have motive. What are your thoughts about her testimony?
Yeah. I agree with Brian on this. I don't think it was necessary to use the GC as a witness in this case. Not only is it traumatizing to relive this, but they could have got evidence that this call was made from the defendant without bringing her on.
Right.
She's basically testifying that she heard the defendant make this call, make a pizza call, but they didn't need to. She didn't need to do that. They could have brought in phone records, pizza records, or whatever it was.
I'm sorry to interrupt, guys, but we have to end it. Great job. We'll be back. Stay with us here at the Law&Crime Network.